Kenya Appeal Court has actually struck down sections of the Cybercrime Act. Now, this is a very big win to Kenyans and those who are content creators and those who show the love for free speech. Now, just for you to know, this Cybercriminal Act bill was signed into law by the then President of Kenya, Uhuru Kenyatta, and Section 22 and 25 of this Cybercriminal Act bill is very dangerous, as anybody can be jailed and anybody can be made to pay a fine if found guilty. It talks about the circulation of fake news, also talk about publication of things that are not certain, and if found guilty, you know, a lot. We're in a time when sometimes you can publish an information, you can do due diligence, but before you want to realize, you see that the information was not accurate as it sounds. So the Court of Appeal has actually struck down nullified these two sections, that the lawmaker should go back and address this issue, that this issue which was signed into law is repugnant to natural justice. It's against natural justice, and that this cannot pass and this should not be accepted in court. You see, this is a very big win. Now, it is only in Kenya where you can have the judiciary having this power to overtake or to nullify an action from the executive bench in Africa. You can rarely see this in CEMAC and in even ECOWAS nations, especially in Nigeria. You never see this in Nigeria. You never. I want you to watch this video.
The Court of Appeal has declared Section 22 and 23 of the Computer Misuse and Cybercrimes Act 2018 unconstitutional. Justices Patrick Kiage, Aggrey Muchalule and Weldon Korir further warned that the judiciary must be alive and alert to the risk that the act can be deployed for political purposes, calling for careful scrutiny of every application before granting any order. Ayub Abdikadir reports.
A three-judge bench of the Court of Appeal found Sections 22 and 23 of the Computer Misuse and Cybercrimes Act of 2018 unconstitutional, in the awarding ruling that they were too broad to the extent that they are likely to net innocent persons. Section 23 of the Act seeks to punish any person who publishes false or fictitious data or misinforms with the intention of passing off the data as authentic. It prescribes a maximum fine of 5 million Kenya shillings or a 2-year jail term or both. The section also seeks to limit Article 33 of the Constitution on the freedom of expression, where there is intentional publication of false, misleading or fictitious information likely to propagate war, incite persons to violence, constitutes hate speech or advocates hate. While Section 23 of the Act deals with knowingly publishing information that is false in print, broadcast, data or over a computer system, calculated to or resulting in panic, chaos or violence among citizens, and attracts a 5 million Kenya shillings fine or a maximum of 10 years in jail or both. The High Court in 2020, 2 years after President Uhuru Kenyatta signed the bill into law, dismissed a case by the Bloggers Association of Kenya, the umbrella body that challenged the constitutionality of the act, leading the association to file an appeal. In the 5 grounds they outlined for determination, Justices Aggrey Muchalule, Patrick Kiage and Weldon Korir found all the other grounds of the appeal by the bloggers' umbrella without merit. Alive to the risks posed to expression owing to politics and governance, the 3 judges of the Court of Appeal recommended in the course of the implementation of the Act, courts and other institutions of the state to pay attention to offence for which an interception order is sought, the period of interception, how data is examined, used, stored and protected from third parties, and provide for the eventual erasure or destruction of the digital evidence.
But now you know that the person who...
A month after the Gen Z-led demonstrations in 2024, Wajir East lawmaker Adan Dawood introduced amendments to the 2018 Act, prompting public outcry. Petitioners, among them the Kenya Human Rights Commission, mounting legal challenge over the changes signed into law by President William Ruto in October 2025, terming them punitive and posing the risk of shrinking the country's democratic space. The ruling comes as a reprieve for Kenya's connected, urban and youthful population, whose governance discourse on social media spaces has seen them bearing the brunt of abductions and extrajudicial killings. Ayub Abdikadir, Citizen TV.
Congratulations, you've passed your GCE or baccalaureate, and now it's time to choose a professional university that opens real doors to your future. Let us introduce you to the African Higher Institute of Technology, a career-focused institution that not only awards internationally recognized certificates, but also guarantees direct employment opportunities upon graduation through its solid network of partner companies and institutions worldwide. This school operates in collaboration with the Cameroon Ministry of Higher Education, UBA Bank, St. Francis Xavier Institute, Canada. Located in Yaoundé, Mendong, away from the noisy town, AHIT provides the following for its students: a free brand new laptop immediately after paying a registration fee of 25,000 francs CFA, free high-speed internet access on campus, hands-on professional training, mentorship from local and international experts, offering courses like local government in accounting, finance and administration, computer engineering, artificial intelligence, biomedical sciences, economics and finance, business and management, arts and education, law and public policy, agricultural sciences. Whether you dream of becoming a software developer, civil engineer, healthcare technician, or business strategist, ICT is your direct path to success. Apply now and take the bold step toward a future of innovation, professionalism, and global opportunity.